Good morning, everyone. My name is Hank de Jong, and thank you for attending our seminar on what goes wrong and how to fix it. The primary focus of today's presentation is to look at the areas where directors can manage their affairs better and therefore protect themselves in the event of insolvency. In isolation, these areas are not particularly complex, but as a whole are often overlooked. During today's presentation, we'll help identify these areas by means of a hypothetical case study and explore in further detail how you can help your clients put protection in place and the benefits of doing this. Prior to embarking on this, I'll touch on the insolvency industry and why obtaining independent pre-insolvency advice is so important for directors. Now, for those in the room who haven't worked with de Jong Reid in the past, I'd like to play a 2-minute video that explains exactly where we fit into the insolvency framework.
We're in a world of hurt.
I thought I'd lose my home.
I am so grateful.
Business failure is gut-wrenching. You feel completely out of your depth. It's all too much. What do you do? Just talk to de Jong Reid. They really understand.
They're not like anyone else. It's very obvious why they're the leader in their field.
Look, our business was in more trouble than I could imagine. I mean, we were drowning in business and personal debt. It was a stroke of luck, really. Somebody recommended that we ask de Jong Reid for help. Actually caring about our personal situation, those two men and their outstanding team, I mean, they guided us through what was an impossible time. I couldn't speak more highly or recommend or thank them enough for everything that they've done for us.
Financially, I'd gotten myself into a real mess. All options were running out. My only alternative was bankruptcy. My accountant had done everything in her power to guide me, but I needed extra advice. De Jong Reid were recommended to me, actually. They pointed out that there was another option, and it worked. De Jong Reid's professionalism and knowledge was outstanding, and in the end, the outcome was so positive for us. I can't say how grateful I am for everything that they've done for me and my family.
As a result of the GFC, I found myself in a position of professional and personal debt that I'd never encountered in 32 years of business. My accountant, she was concerned about my well-being, and she suggested I talk to de Jong Reid. Ben, Hank and their team had the knowledge and the experience to create a plan to get me through my financial train wreck. It not only succeeded in resolving all my debt issues, but it removed a lot of that personal stress of not knowing which way to turn.
Credibility, proof, track record, results. That's what you can expect from de Jong Reid.
De Jong Reid walked us through everything. They virtually held our hand the whole way through it.
As you've seen in these testimonials, we've successfully helped others in the same situation. We can do that for you.
Come in and talk to us. There's no cost for this consultation. We're here to help.
The insolvency framework in Australia is such that a liquidator or trustee in bankruptcy is appointed to represent creditors and not necessarily focused on obtaining the best outcomes for the director or the business owner. As such, the liquidator or trustee could likely conflict themselves from taking on an insolvency appointment if certain specific advice has been given to the director or business owner in relation to their personal circumstances. Therefore, an insolvency practitioner who is prepared to take on an appointment has not provided the specific, comprehensive and independent advice on how best to manage the insolvency event from both a corporate and personal perspective. This advice is crucial in obtaining the best result for the business owner. Independent advice should be in writing, and in the case of corporate insolvency, should not only cover the corporate issues, but should clearly identify the appropriate course of action and consideration of the director personally. Because de Jong Reid does not take on the role of a liquidator or trustee, our clients can be confident of receiving this specific, comprehensive and independent advice. It's imperative that company directors and individuals seek this advice prior to entering any form of formal insolvency. As we work through our presentation this morning on what goes wrong and how to fix it, the benefits of good pre-insolvency strategy become very clear. Now I'll hand over to my business partner Ben Heaney to walk through our hypothetical case study.
Thank you for allowing us to come to your breakfast and have a discussion with you about what goes wrong and how to fix it. This morning, my part of the presentation is going to focus on 4 key areas, and they're up on the screen. They're corporate structures, related party loan accounts, ATO debts and trade creditors, and management of financial institutions. Now, these are areas that business owners frequently mismanage. In the room here, there's a healthy combination of accountants, lawyers, finance brokers and business advisors who are very familiar with these topics. And these areas on their own are certainly not complex. However, they're very, very worthy of a detailed discussion because in the combination of these 4 areas, it is something that combined business owners frequently mismanage these areas. And if we as advisors can help business owners to better manage these areas, then as you'll see, the outcomes in insolvency could be so much better. Now, to help us identify and explain the many areas that directors need to watch, we're going to introduce you to Bill and Mary and Bill and Mary's Dry Cleaning Proprietary Limited. This is a hypothetical case study, and what happens to Bill and Mary is everything that could possibly go wrong. And we're going to look at that and then discuss how Bill and Mary could go about fixing it. If we now do a quick background on Bill and Mary, they operated a dry cleaning business, hence the name. They did have a trust structure and they did have a corporate trustee. They also had an asset holding company for the purpose of holding assets. Bill and Mary were both directors of each entity, and both Bill and Mary did have personal assets in their own name. They've been trading this business for 15 years, and the business fell into hard times because Bill was diagnosed with bowel cancer some 18 months ago. Although the business had afforded Bill and Mary a modest lifestyle over the years, it had fallen into financial difficulty. During this period, wages increased because someone needed to replace the duties that Bill was doing, and all staff were employed on a casual basis. To add to the financial pressure, Bill needed to draw extra money out of the business to fund increased medical costs. The good news now is that Bill's back at work, he's in remission, and they, both Bill and Mary, think that this is a good little business and it does have a future. The bottom line is the business is profitable, but it has fallen into a hole that the business just can't trade out of in its current format. Now, if we look in a bit more detail at the business, the first thing that we would do is run a company search, and we confirm that Bill and Mary are directors of the business. This is followed very closely by a PPSR search. Interestingly, we saw that the bank that had provided an overdraft to this business had not registered a security interest. We did, however, see that Jones's dry cleaning products had registered a charge over the business, and that was in relation to products supplied. Now, if we look at the assets, we had cash at bank of $15,000, debtors of $50,000, stock of $15,000. Now, there was a loan owing from the asset holding company back to this trading entity of $55,000. There was a VW work van of $20,000, so total assets $155,000. On the liability side, we had an AZZ overdraft, and that was secured against Bill and Mary's home. That was for $100,000. There was trade creditors of $75,000, super of $15,000, and a loan that Bill and Mary had advanced the company of $100,000. There was also ATO debts that were comprised of PAYG and GST of $300,000. So the total liabilities were $590,000. This business in the current format was insolvent. Now, the situation was the tax office had commenced wind-up proceedings against the business. So a wind-up notice had been received, which meant an official liquidator would be appointed to the company in a matter of weeks. Okay, now if we look at Bill and Mary's assets. So as mentioned earlier, Bill and Mary did have an asset holding company, and this was incorporated 4 years ago. The purpose of this was to protect business assets such as plant and equipment and intellectual property. The snapshot's quite simple. It's got the plant and equipment worth $55,000, and it's got the loan owing back to Bill and Mary's dry cleaning of $55,000. On the personal side, as I mentioned, Bill and Mary did have assets. There's a family home worth $800,000, which is jointly owned. There's an investment property worth $400,000, which again is jointly owned. There's a motor vehicle for Bill, $7,000. There's a motor vehicle for Mary, $15,000. There's a fishing boat, that's worth $20,000. This fishing boat's registered in Bill's name, however, it was paid for out of the company account very recently. There's jointly owned shares, $5,000, healthy self-managed super fund balance of $500,000, and there is the loan that Bill and Mary gave to their business of $100,000. So we've got $1.8 million in assets. On the liability side, we've got the AZZ Bank with a joint home loan, so that's $660,000 secured against the home. We've got a redraw facility that's been drawn down on for $100,000. That was the money that Bill and Mary lent back to the business. There's an investment property loan, again with the same bank, AZZ, and that's got a balance of $200,000. Credit cards in Bill's name of $15,000 and a director penalty notice of $15,000. So the total liabilities are $990,000. So the bottom line is Bill and Mary have assets in their own name, and these assets are at risk. So part of what we need to look at is what is going to be the outcome for Bill and Mary, and how are they going to get the best outcome for their personal situation, given that they've got a winding up notice on foot of Bill and Mary's dry cleaning. Now, I did mention before that there's a DPN liability of $15,000. I'm sure a lot of you know in the room that a director can be held personally liable for some tax, and that is superannuation and PAYG. And there are in fact two types of director penalty notices. There's the old style, where when the director received that notice, they had 21 days to put the company into liquidation or administration, and should they do that, the penalty would be remitted, so they would get out of having a personal liability. Then there's the new style, and the new style is where the liabilities, so superannuation and PAYG, are not reported within 90 days of the due date. With this new style, the directors cannot get out of the personal liability by simply appointing a liquidator to the company. Now, this is the situation that Bill and Mary were in. So, up on the screen here, again, is the 4 key areas that I'm going to go through, and these are the areas as a whole that directors frequently mismanage. So, we're going to take a closer look at what went wrong and how we can fix it. So the first issue is under corporate structures, and we're going to look at multiple directorships. So whilst Bill and Mary did utilise a trust structure, and they did have a corporate trustee, both Bill and Mary were directors of this corporate trustee. So this did expose both Bill and Mary to the DPN liability, and it also exposed both Bill and Mary to personal guarantees to trade creditors, because the trade creditors wanted the guarantees of both directors of the company. At least in this situation, Bill and Mary did have a corporate trustee. In our job, we still see a lot of clients come to us where they are individual trustees of a trust that operates a business. In those circumstances, an individual trustee is ultimately responsible for all of the trust debts, not just the director penalties or the personal guarantees, such as in Bill and Mary's case. Okay, now if we move on to the second issue, this is a big one. it's under corporate structures, and it's the asset holding company was ineffective. We do see this all the time. So the background is approximately 4 years ago, Bill and Mary identified that their business needed new equipment to be competitive. This new equipment would cost $55,000 and it would bring in substantial efficiencies. So they went to their accountant for advice, and their accountant advised them to set up a separate company to own the new plant and equipment, and at the same time suggested that this entity should also own the intellectual property, such as the phone numbers and website. The accountant helped Bill and Mary to incorporate the new company. Sometime later, Bill and Mary then went about purchasing the new plant and equipment and transferring the website and the phone numbers to the newly formed Bill and Mary's Assets Proprietary Limited. Utilising an asset holding company was really good advice, but it was Bill and Mary that had poorly executed the implementation of it. The first concern was that Bill and Mary used the trading business's overdraft to pay for the new plant and equipment. This created a liability of $55,000 owing back to the trading entity. Should the trading entity go into liquidation, then the liquidator would demand payment of this $55,000 loan account. Now, the reality for Bill and Mary was a liquidator would be appointed in a matter of weeks. The second concern about the corporate structure was that there was no contract of sale with regard to the intellectual property, and of course no consideration had been paid by the asset holding company for the intellectual property. So again, should the trading entity go into liquidation, it's likely the liquidator would assert ownership over the website and the phone numbers and the goodwill. The third concern was that plant and equipment was in the possession of the trading entity, and the asset holding company had not registered its interest in the equipment on the PPSR. So should the trading entity go into liquidation, the liquidator of the trading entity would in effect be able to sell these assets and return the proceeds to the trading entity and not the asset holding company. Now, the PPSR, or Personal Property Security Register, is now the regime that has replaced the old fixed and floating charge and the old retention of title clauses on invoices. This is where banks, financiers and suppliers do register their interests. So only by registering on the PPSR can someone have a valid security interest. The point here is that business owners do not seem to be utilising this system to the extent that they should, and you will see this all throughout this presentation. So the PPSR system has certainly changed pre-insolvency strategy, and it's certainly changed the outcomes that directors receive in insolvency depending on how they've managed that regime. All right, finally the third issue under corporate structure was tax grouping. The trading entity and the asset holding entity had been grouped for GST. So this meant that on liquidation of the trading entity, the GST debt would rest with the asset holding entity. Therefore, in Bill and Mary's situation, the asset holding entity is going to need a separate insolvency strategy. Okay, so if we take a look at how we can fix these corporate structure issues for Bill and Mary. So the first one, multiple directors. This is a very easy solution, which is simply to give consideration to which party in a matrimonial situation is best being exposed to potential liability of a trading business. Careful consideration should be given to the asset protection strategy that people are putting in place from day one, where one party holds the assets and the other has the potential liability from the trading business risk. Now, I know this sounds very 101, but in practice, directors fail to maintain their corporate structures that you, as advisors, have recommended, and they also fail to manage their asset protection strategies as they were intended to be managed. Now, later on in Hank's part of the presentation, you'll see how something as simple as making a home loan repayment from the wrong person's account can put an asset protection strategy in jeopardy. In relation to issue number 2 of the asset holding company being ineffective, I listed 3 concerns that could have quite easily been addressed 4 years ago. So in relation to the first concern, a rental agreement could have been put in place between the asset holding entity and the trading entity. This rental amount could have been used to offset the $55,000 loan account. If this had occurred, now when Bill and Mary have this problem, there would be a very little loan account, if any, in existence. Now, in relation to the second concern I had, a commercial dollar amount for the website and the phone numbers could have been determined by simply valuing goodwill at the time. Now, the valuation on goodwill probably would have been modest after they took into account Bill and Mary's fair market salaries. The asset holding company could have paid the trading entity for the goodwill over the 4-year period, something that could have easily been put in place. Now, in relation to the third concern, and that was the physical plant and equipment, for that to be safe from the hands of the liquidator, then in an insolvency event, the trading entity and the asset holding company would have needed to enter into a PPS lease. This would have cost Bill and Mary around about $1,000. They would have needed to have registered a PIMSI, and had they have done this, it would have protected the plant and equipment from the liquidation that was about to take place. Finally, the solution for tax grouping, it's simply not to group taxes unless there's a really good reason for it. Grouping, in effect, does cancel out some of the benefits of running a PTY LTD corporate structure. Now, the good news is that even though Bill and Mary don't really have the protection that they thought that they did from this asset holding company, we can still improve their situation by undertaking a corporate restructure. However, the outcome certainly isn't as good as what it could be if Bill and Mary had managed their corporate structure better than what they did. Now, if we move on to the next issue, which is related party loan accounts, and we're going to talk about unsecured directors' loans. So Bill was diagnosed with cancer, and as you could imagine, the business was faltering at this time. The trading entity ran out of working capital, and it did need an injection of funds, something that's common in most businesses from time to time. Bill and Mary did have redraw available on their home, and they did make a series of redraws that they put into the business, totaling $100,000. Now, these loans were unsecured. So should the trading entity go into liquidation, then Bill and Mary would have to line up with the other $500,000 worth of unsecured creditors for their return. Now, in these situations, it's very unlikely that a reasonable return could be expected from a liquidation event. So it would be cents in the dollar. The second issue under related party loan accounts is inter-entity loans. So the inter-entity loan between the trading entity and the asset holding entity caused by the initial purchase of the plant and equipment has been addressed in the corporate structure section. So the point I'd like to labour on here is that loan accounts within a corporate group to and from directors or within the companies within the group have such a huge bearing on the outcomes in an insolvency event. And in general, we're finding that business owners are not placing enough attention to managing these loans throughout the year and throughout their corporate structures or asset protection strategies. Again, you'll see a bit later on why this is such an important point. Let's now look at how Bill and Mary could have addressed their related party loan accounts. So the first issue was unsecured directors' loans. Now, this could have so easily been dealt with by Bill and Mary simply entering into a loan agreement with the trading entity at the time of the first advance and securing their interest on the PPSR within 20 days of making the advance. This would have cost Bill and Mary, again, about $1,000, and in effect would have positioned them first in line to receive their payment after payment of superannuation in a liquidation scenario. If Bill and Mary had secured their loan, strategically it would have given them the following options. Now, in the case of Bill and Mary, they wanted to retain the business, and a corporate restructure would be the appropriate strategy to do this. Now, should Bill and Mary's loan to the business be secured, then Bill and Mary would have been entitled to the sale proceeds as a secured creditor. As you know, unfortunately for Bill and Mary, their loan was unsecured, and so they would only be entitled to a share of return that all of the unsecured creditors had, which was to split it up amongst the other 500,000. Similarly, if Bill and Mary decided that they might like to exit the business and move on, then they still, if they had secured their loan, would have been entitled to the first 100,000. So Bill and Mary could have collected in the debtors and sold the motor vehicle. Now, strategically, they could have paid that money back to themselves in priority as a secured creditor, and then they could have paid out the AZZ overdraft from their personal bank account. Now note, I mention this because the AZZ overdraft was unsecured, so it was not advisable for this to be paid out of company funds, because it could have been treated as both a preference or an unreasonable director-related transaction, because it was in effect reducing Bill and Mary's loan against their property. Let's now look at how to fix inter-entity loans, and the point here that we're going to be talking about is related party loan accounts. So where possible, there should be a plan for considered management of loan accounts from an asset protection point of view, and not just tax planning. The existence of inter-entity loan accounts where one entity is providing equipment or services from a trading entity can be managed by documenting rental agreements, service agreements, and importantly, ensuring consideration is paid between the entities. Additionally, when your clients are doing their year-end tax planning, consider whether they can physically pay distributions to the bucket company or the beneficiaries before the end of the financial year. This will alleviate unpaid present entitlement issues, which again are a collectible loan in a liquidation scenario. Quite often we see instances where the trading entity has been directly loaning money to other entities in the group or been funding new ventures. Could the flow of funds be managed better? That's the question. For example, could the flow of funds have been better to flow from the trading entity to where last year's profits were supposed to be distributed to? Or alternatively, could the flow have been used to reduce the payout, to reduce other inter-entity loans that may exist at that point in time? Now, I raise these points because a liquidator will always look at cash at bank movements. A liquidator will place more weight on bank transactions rather than general journal entries at the end of the year to tidy up a director's poor loan account management. All right, the third key area that directors seem to continuously mismanage are ATO debts and trade creditors. So the first issue that we're going to look at here is failure to report superannuation. Now, Bill and Mary were good with compliance. They kept their financials up to date, and they were aware that they needed to lodge their business activity statement within 90 days of the due date to avoid a lockdown director penalty notice. Noting again that the lockdown director penalty notice is the one that cannot be extinguished by placing a company into liquidation. Now, all in all, Bill and Mary had satisfied their requirements with their lodgements, but Bill and Mary did have outstanding superannuation, and they had not reported it by lodging the SGC form within 90 days of the due date. So because unpaid superannuation had not been correctly reported by Bill and Mary, they were held personally liable for superannuation. And as you know, the ATO had issued them with the lockdown director penalty notice. Now, on a side note, if anyone in the room has clients that the ATO has classified as a large withholder of PAYG, please let your clients or make your clients aware that the ATO has no approved form for the company to notify of the PAYG payments withheld. So the view of the ATO is that PAYG for large withholders is taken to have been reported when it is remitted. So this is a major risk for directors of large withholders, and I would say that most of them are unaware of that. Okay, on to the second issue in relation to ATO debts and trade creditors, and that is unaffordable payment plans. So due to Bill's illness, the ATO had been quite accommodating over the last 18 months. However, in the last 6 months, they had applied quite a lot of pressure to Bill, and they were insisting on a payment arrangement that the company simply could not afford to pay. Not only was it inevitable that the trading entity would continuously break this payment arrangement, in the event of liquidation, these payments to the ATO would have been considered preferential and the money would have been demanded back by the liquidator. Now, in this case, it's possible for the ATO to co-join the director personally to this claim, therefore allowing the ATO to pursue the director for payment personally. So as part of the information that the ATO were demanding from Bill and Mary, they asked for a debtor's ledger. And using this information, the ATO then issued a garnishee against Bill and Mary's largest debtor. Now, a garnishee payment is not considered a preference payment, so it was quite a likely tax for the ATO to garnishee a debtor first before they commence wind-up action, which is exactly what happened in this case of Bill and Mary. Okay, so if we look at the third issue under ATO debts and trade creditors, we're going to talk about caveats and equitable interests. Because Bill and Mary were both directors of the company, they were both included on the credit applications for their suppliers. All creditors had been given personal guarantees, and luckily Bill and Mary did keep a register of their credit applications, which meant that they could easily ascertain what their personal liability situation was. Now, one of these applications had an equitable interest clause with a debt of $20,000. Unlike a caveat, Bill and Mary had unknowingly given an equitable interest in their personal property, which gives the creditor the right to enforce the sale of that property. This is becoming very common in credit applications. So a caveat, like a mortgage, is a legal interest in property. It does not confer or imply ownership of the property. An equitable interest, however, does assert such an ownership. So a caveator that asserts an equitable interest is effectively saying that they own a share of the property up to the amount of the debt owed. Importantly, a party with an equitable interest can force the sale of the property, whereas a caveator with a legal interest cannot. Now, this is a very big issue for directors of companies that are trying to manage their way out of a difficult financial situation, and they have creditors forcing their position on the home property or other properties in their own names. Okay, on the screen here you'll see page 2 of 4 of a standard credit application. I don't expect you to read it. I struggle to read it just when it's in a normal A4 font. Now, it reads, as security for all amounts due to the supplier from time to time, the customer charges all of its legal and equitable interest, both present and future, of whatsoever nature held in any and all real property to the supplier. Business owners need to read the fine print. They need to understand what they're signing. Most of your clients would have quite a number of these that they don't really know what they've signed away. Okay, so let's now take a look at how Bill and Mary could have better managed ATO debts and trade creditors. So first one is failure to report unpaid superannuation. Unfortunately, there's no magic here. They needed to report non-payments of superannuation by lodging the SGC form within 90 days of the due date. The problem for Bill and Mary was they simply did not know that they needed to do that. Now, if you have directors that do have a problem, but they are going to continue on and they can trade out of their difficult situation, make sure that they are mindful of lockdown director penalty liabilities and get them paid. So if I was in that situation where I had a director penalty that I knew about, I'd certainly be giving that special attention whilst I was trading out of a difficult situation. Now, the solution to issue number 2, which was an unaffordable payment arrangement, it's simply not to enter into unaffordable payment arrangements with the ATO in the first instance. No good can come of it. In Bill and Mary's situation, if they hadn't have tried to enter into an unaffordable payment arrangement, then they certainly wouldn't have got a garnishee over debtors and they would have been better off. The alternative here is to seek an appropriate pre-insolvency strategy earlier rather than later. Now finally, the issue number 3, which is in relation to caveats and equitable interests. The only option Bill and Mary had was simply to pay out the creditor. There's nothing that they can do to remove the caveat or equitable interest that that supplier had. So now, of course, this could have been avoided by Bill and Mary if Bill was the sole director of the company and Mary did own the home and the investment property, but as we know, it wasn't the case here. In the case of Bill and Mary, where they were joint directors, in hindsight, what they could have done was cross out the equitable interest part of that credit application. All right, the fourth and last key area that we're going to consider is management of financial institutions. So the first issue here is all borrowings were with one bank. Bill and Mary had been loyal customers of the AZZ Bank for 20 years. 5 years ago, Bill and Mary did decide an overdraft would be a good thing to have just in case they needed some extra funding. They always had a reasonable debtors ledger, but some of these debtors took 60 days to pay. The AZZ Bank agreed to give the trading entity an overdraft and also gave the facility at really competitive rates because it was secured against Bill and Mary's home. Now, the first concern with Bill and Mary's financing structure was that the same lender for the home was used for the business. This meant that in an insolvency event, in an insolvency event of the business, it would automatically default their home loan. To make this worse, Bill and Mary had used the same bank to finance the purchase of an investment unit, which had increased in value beyond Bill and Mary's expectations. Now, Bill and Mary were on the front foot here, and they had a contract to sale on this property for $400,000. They planned to pay out the $200,000 in bank debt and use the balance of funds, being $200,000, to tidy up their personal liabilities. The AZZ Bank, however, was uncomfortable with the business and the ATO situation and having the company shortly to enter into liquidation, and they exercised their power under the All Monies Clause to take the proceeds and reduce the bank debts by paying out the overdraft and reducing the home loan. So often banks do have what is known as an All Monies Clause in their documents. So we regularly have clients that we see have a number of assets that they plan to sell down to access much needed cash, and they're very surprised to learn that very late in the piece that the bank's going to keep 100% of those proceeds and apply it to debt reduction of the bank's facilities. The second concern here was that in the financing structure was the business facility, so the overdraft was not secured on the PPSR. The bank solely relied on the home as security. So this meant in liquidation, the bank would not be paid out in priority, and ultimately the bank would call on the home as security and sell the home if Bill and Mary could not pay out the bank debt from their own personal assets. All right, so let's take a look at how financial institutions can be better managed. So business owners should always separate their home loan from their lending. Furthermore, Where possible, it would have been prudent to have the investment property with a totally separate lender. Bill and Mary had no control because all their eggs were in one basket. And this is overlooked quite often where there is that existing relationship with the business banker, because it is easy for your clients or business owners to go back to the same person. It's got all the information that can make the approval much easier. But in an insolvency event, it's a huge problem, and if your clients can separate their lenders, including, of course, the investment property, if possible, so just separate everything as much as possible, it does improve their position. Now, the second issue was that the bank had not registered the fixed and floating charge, or had not registered a GSA over the business for the overdraft on the PPSR. Now, because of this failure, it meant that, of course, the overdraft couldn't be paid back in priority, which was a problem for Bill and Mary because that was secured against their house. Quite simply, all Bill and Mary needed to do was do a search on the PPSR at the time the bank lent the money and confirm that the proper securities were in place. So, if we now take a look at the strategy for Bill and Mary. So as we noted earlier, Bill and Mary wanted to retain this business, and this is how we went about doing it. So again, to recap, there's a winding up notice. A liquidator is going to be appointed to Bill and Mary's dry cleaning in a matter of weeks, and we need to move quick. Timing is of the essence. First thing we do is we resign Mary as a director of both the trading entity and the asset holding entity, because no benefit can be achieved by having both Bill and Mary as directors of a company in liquidation. Now, Bill and Mary desperately wanted to retain the business, so an asset or a commercial corporate restructure was the best course of action. So plant and equipment was valued, and that valuation came in at $35,000. Goodwill was valued. That came in at $25,000. A new entity needed to be established, which Bill was the director of. The new entity would then enter into a contract, and it would purchase the plant and equipment from the asset holding company and the goodwill from the trading company. Leases would need to be assigned and staff re-employed. Bill and Mary were of preservation age, so they were able to access their self-managed superannuation fund. And it was good that they could do that, because that's how they funded the purchase of this business from the company Bill and Mary's Dry Cleaning Proprietary Limited. After completion, Bill and Mary kept trading the business just like normal. There was no interruption to their business operations, and they now did not have the burden of the insurmountable debts that they could not trade out of. Now, a few points are that we note that the overdraft had been paid out from the sale of the investment property. Bill and Mary were now unsecured creditors for an additional $100,000. Unfortunately, again, they would only receive some cents in the dollar return in liquidation. Had the bank have registered the ORPAP on the PPSR at the time of advancement of the original overdraft, Bill and Mary could have stood in the shoes of the bank, utilising the bank's security to get some priority, but unfortunately, again, that wasn't the case. Now, I did mention at the start that Jones's Dry Cleaning Products had registered a PIMSI on the PPSR, and this meant that Bill and Mary simply were able to return that stock to Jones's Dry Cleaning, and that was a good way to deal with that $15,000 trade creditor, and it also, of course, then automatically dealt with the $15,000 personal guarantee they had given that trade creditor by returning the stock. Now, debtors were collected in, and superannuation of Bill and Mary's Dry Cleaning Proprietary Limited was paid out by Cashet Bank. Now, superannuation is a priority creditor, and payment would not constitute a preference payment. Importantly, this solved the personal liability problem in relation to the director penalty notice that Bill and Mary had. The court finally appointed the liquidator, which then brought finality to the $500,000 of insurmountable creditors. The sales proceeds were distributed by the liquidator based on priority. Now, whilst the fishing boat that we mentioned earlier was registered in Bill's name, it was clear that the company had recently paid for it. Bill and Mary knew the liquidator would lay claim on this boat. The liquidator would assert that the company owned the boat, or in the alternative, the director held it in trust, or it was simply an unreasonable director-related transaction. Therefore, Bill and Mary were prepared to return the boat to the liquidator. Now, because the GST was grouped, the majority of the $300,000 tax debt was now payable by the asset holding company. So Bill and Mary had to appoint a liquidator separately to the asset holding company to bring conclusion to that problem. This did come at an additional cost. The trade creditors had the personal guarantees of Bill and Mary, and not to mention there was that supplier with the equitable interest. So once again, Bill and Mary did need to access their self-managed superannuation to pay out these trade creditors that had guarantees, and that was another $60,000. Now, the bank agreed to leave the home loan in place, and there was no need for a personal insolvency strategy because it had all been solved at the corporate level. Now, if we look at what the cost of solving these problems for Bill and Mary was, it was quite substantial and certainly more than what it should have been had of Bill and Mary managed those 4 key areas better. So if we take a look at what it cost Bill and Mary to retain their business and deal with any personal liability fallout. So there was $60,000 that they needed to purchase the assets of the business. There was $60,000 that they needed to settle with trade creditors that had their personal guarantees. There was the $100,000 that was used from the proceeds of the investment property to pay out the overdraft, and there's an additional $12,000 of fees required by the liquidator to liquidate the asset holding company. So there's a total cost there of $232,000. Certainly their position is greatly improved, but it could have been better. I'm going to hand you back over to Hank now, and Hank's going to talk to you about Mr. and Mrs. Smart. And they certainly did do things better, and Hank's going to talk in detail about the outcome that Mr. and Mrs. Smart achieved through the same situation, but managing their affairs the way that us as advisors would like our clients to do so. Thank you.
Thanks, Ben. Now, there was another couple who did things a little differently, and would like to introduce you to Mr. and Mrs. Smart. Now, Mr. and Mrs. Smart were a couple in exactly the same predicament as Bill and Mary. However, they had obtained specialist advice from their lawyers, from their accountants and business advisors throughout the trading of the business, and they'd handled their affairs in a much more diligent manner. Now, Mr. and Mrs. Smart did a number of things differently, and I'm just going to run through these points briefly on this slide and then go into them in more detail on the next slide. First of all, they used a sole director in relation to their corporate structure. All family assets were registered in the name of the non-director spouse. A PPS lease was entered into between the asset holding entity and the trading entity, which over time had extinguished the inter-entity loan account. They'd prepared a license agreement between the asset holding entity and the trading entity for the use of the intellectual property and assets, and consideration was paid. They'd registered all advancements that they had made personally to the business as loans and recorded those on the PPSR. They'd purchased their own assets, their fishing boat and so on, using personal funds rather than company funds, and they didn't group their taxes. And they separated their business lenders from their personal lenders. Now, the outcome for Mr. and Mrs. Smart was vastly different, and now we're going to look at this in more detail. So the same wind-up notice had been issued with the same urgency. Now, Mr. Smart had entered the PPS lease between the asset holding company and the trading entity, as I just mentioned, when he commenced the structure. Now, Mr. Smart, upon receiving the wind-up notice, immediately terminated the licence agreement between the asset holding company and the trading entity on the grounds of insolvency, therefore severing the tie between these two entities. There were no inter-entity loan accounts. The asset holding company, between the asset holding company and the trading entity, as these had been well managed. Now, the trading entity had paid a fee for utilising the assets, and this had been offset against that $55,000 loan account and had been offset out during the previous years. So, secondly, the asset holding company had secured its interest in the assets by registering a PPSR lease against the trading entity. So moving forward, a new entity was set up and which executed a new licence agreement with the asset holding company to operate the business moving forward. A new lease was negotiated then with the landlord moving forward. Similar to Bill and Mary, Jones's Dry Cleaning Products held a PIMSI, and the stock was returned, which lowered the overall creditor position to around $60,000. Now, Mrs. Smart had also personally loaned the trading company $100,000. However, she had secured her loan on the PPSR and therefore was a priority creditor. Now, this meant the strategy for the Smarts was to simply collect in the debtors and pay these proceeds totalling $50,000 to Mrs. Smart. She was the priority creditor. Mrs. Smart then used this $50,000 to pay part of the unsecured business overdraft. Note, as mentioned earlier, as the overdraft was not secured by a PPSR charge over the company, if the $50,000 went direct to the overdraft, the liquidator could have tried to recover those funds. Mr. Smart utilised the $15,000 cash at bank to settle the superannuation. Now, the only remaining asset in the business was the motor vehicle, which was then sold to Mrs. Smart, and consideration was offset against her secured loan. So, Mrs. Smart also had a fishing boat in her name. However, she purchased the boat by redrawing funds from the home loan, unlike Bill and Mary, who'd used the business overdraft. The boat was obviously safe. Now, GST was not grouped, and therefore the tax debt rested with the trading entity in its entirety and not the asset holding entity. This avoided the necessity to liquidate the asset holding company. Now, Mrs. Smart sold the investment property, or her investment property. However, the investment property was with a separate lender. The proceeds from the sale were used, the $200,000 proceeds from the sale after repaying the bank were used to pay out the balance of the overdraft, the $50,000, prior to the company going into liquidation. Mrs. Smart retained the balance of the funds from the sale of the investment property, some $150,000. Now, the Smarts did not need to access their superannuation to solve their financial problems. Mr. Smart was the sole director of the company and had signed personal guarantees. He did not have any assets at all in his name, as Mrs. Smart owned the properties. Mrs. Smart was able to offer unsecured creditors 20 cents in the dollar as full and final settlement, which was accepted on the basis that if the creditors pursued Mr. Smart into bankruptcy, they would receive nothing. Now let's look at the net effect of Mr. and Mrs. Smart's good business management and planning. The costs that Mr. and Mrs. Smart incurred in exactly the same transaction were simply $50,000 to pay out the balance of the overdraft, which was again secured from the sale of Mrs. Smart's investment property, and $12,000 to settle with the unsecured creditors, the offer that Mrs. Smart put up for Mr. Smart's personal guarantees. So the total cost to Mr. and Mrs. Smart to bring finality to this business problem and to wipe the slate clean to move forward was approximately $60,000. In summary, both scenarios saw the clients able to retain the business, continue to generate income, avoid personal insolvency. However, the financial impact was significantly less in the case of Mr. and Mrs. Smart, some $170,000 less. We all have clients that manage their affairs just like Bill and Mary. The good news is that most of them have not suffered a significant event that has impacted on their financial well-being. Most Bill and Marys are blissfully unaware of the exposures and bubble along in their day-to-day activities. As professional advisors, there's a massive amount of value that we can all add that can be done for these clients to clean up their affairs the right way and well before an insolvency event comes to pass. Let's look at how you can help your own Bill and Marys right now and how improvements can be implemented. What if the trading entity owns all the IP and substantial assets? No problem. Most small businesses start with one company and then grow. Why not do a corporate restructure now? Get the IP valued, get the assets valued, and sell it to an asset holding entity. Set up a rental agreement or a license agreement between the two entities and make the payment over time, noting that payment must be made. We see many situations where IP and assets are transferred by way of a sale contract, however not supported by valuations, and no consideration is paid. These structures must be done properly to give the necessary protection in an insolvency event. If you have a situation where your Bill and Mary have joint directorships, look at changing it now. It's okay if PGs have been given by both directors. In that case, we recommend that the resigning director sends a letter to suppliers determining and revoking any further guarantees. At the same time, the remaining director can enter into a new supply agreement. In the normal course of trading, any amounts owing to creditors that the outgoing director has guaranteed would be paid out. What if both parties owe the company money via a joint directors loan account? No problem. There's time to manage this out. The most important outcome is that the party who has resigned and now owns 100% of the family's assets repays their debts to the company. Look for opportunities for this to be solved over time, maybe via distributions. What if the family home is owned by both parties and there's substantial equity? No problem. The non-director could purchase the 50% share in the property from the director. In some states, Queensland, stamp duty on the 50% would be payable, so an educated assessment will need to be made on the trading risks of the business. In our opinion, even the biggest and best businesses can suffer unforeseen financial hurdles. The important thing here is that the sale of equity needs to be well documented, it needs to be commercial, and consideration needs to flow between the parties. There is absolutely no problem with a payment plan over time. We see a lot of asset transfers where no consideration is paid and the assets simply given. This will not stand up in an insolvency event. Note that a trustee has the ability to pursue undervalued transactions for up to 5 years and unlimited timeframes to claw back if a transaction is deemed to defeat creditors. Very importantly, if you go to the trouble of changing the property to the non-director, you need to consider the flow of funds to make loan repayments moving forward. In an event of insolvency, if it's found that the director or non-home owner spouse was making or contributing to the home loan payments, it could be argued that he or she is acquiring an equitable interest in the property. Each payment he or she makes could be seen as increasing his or her equity in the property. It's important not only to make sure that the family home is in the name of the non-active partner, it's also important to make sure that this partner makes all the home loan payments moving forward. This can simply be done by the non-director receiving an income from the business. This can be banked into an account in the non-director's name solely. All home loan payments could come from this account. In summary, it's important that the non-director is making those payments. What if both parties had loaned the business substantial amounts of money and one director was to resign? How do you deal with the non-director's loan account? Consider the director temporarily using company funds to repay the resigning director's portion of the loan. This resigning director can then use these funds to pay the director for his 50% of the house. The director could then lend these funds back to the company after executing a loan agreement and correctly securing the loan on the PPSR. What if the director has loaned money to the company and not taken security within 20 business days? No problem. You can still improve the situation. The director can take security now. If your Bill and Mary registered a security interest now, outside of this 20-day registration window, the security is considered green. If the company went into liquidation within 6 months of the date of registration, the security interest is automatically voidable by the liquidator. Further, if 6 months passes, the security is potentially voidable under the corporation's law and would be open to challenge by a liquidator. However, the longer that security remains in place, the stronger it will become. An important consideration is why was it that the company's best interest to grant the security after it had already received the money? If the company was receiving ongoing loans, this may be appropriate. But if the lender is just trying to turn an unsecured debt into a secured debt, it may not. In our opinion, it would be a much stronger position to have an interest registered rather than not. What if the business overdraft is secured by the family home? Whilst in business we take calculated risks, we strongly believe that the family home should never be used to support business debt. Consider using debtor finance to pay out an existing overdraft facility. Debtor finance is advancing funds against the debtors and does not require bricks and mortar security. Whilst marginally more expensive, in our opinion, a much more prudent way for businesses to fund working capital. When it comes to banking arrangements, your Bill and Mary should review their banking arrangements now. Separating lenders is doable when times are good. Keep investment properties separate from the family home. If there are business lending facilities in place, have a really close look at the lending covenants. Breach of lending covenants is something that catches directors off guard all the time. Often the bank's credit departments set unrealistic lending covenants without really understanding the business, and the business banker that is putting the deal together usually does not pay a great deal of attention to them, but it's rather focused on getting the deal across the line. Now let's go through each of the 4 key areas and see what the take-home is. The first area was corporate structures. Now there we go. It's critical to avoid unnecessary joint directorships. Hold IP and plant in a separate entity. Manage a corporate structure in line with the documentation prepared, such as license agreements, rental agreements, and loan repayments. And avoid grouping tax provisions. In relation to related party loan accounts, the take-home is secure all director liability loans on the PPSR immediately, even if outside of that 20-day registration window. Monitor and manage inter-entity loans with asset protection in mind. When dealing with the tax office and trade creditors, it's important to report unpaid superannuation, retain a copy of all credit applications signed, set up a PG register, read credit applications properly before signing, with special attention given to caveat and equitable interest clauses, and consider striking these out. And refrain from entering into unaffordable payment plans. And finally, in relation to management of financial institutions, the more separation that exists between the business and personal lenders, the better. After reviewing Mr. and Mrs. Smart's position, you can see why proactive directors seek the right advice early before an insolvency event comes to pass. This slide is a snapshot of the various areas that the de Jong Reed service can assist company directors with: evaluating insolvency alternatives, design and managing insolvency strategies, managing liquidations, managing bankruptcies, cash flow finance, significant event analysis, PPS strategies, and business restructures. We're a national firm with offices covering the eastern seaboard. One of our key value adds to our referring accountants and lawyers is that we do not charge for our initial consultation and comprehensive written advice. It's free. We spend significant time researching and preparing our strategies for your clients. Please use our strategists as a resource. Call them up. They're happy to discuss scenarios and bounce ideas around. Should a client choose to engage us, our services are in relation to implementation. What de Jong Reed is about is project management and navigating your client through their unique situation to obtain the best result possible. This brings us to a close, and we hope that you found this morning's presentation a good reminder of the basic things that can go wrong. So thank you very much for your time.